another session of CaN, Gallant Current Affairs and News Analysis. So let us look on to today's topic. I have 6 topics with me here today. I have about the section 8.4 of Representation of People Act 1951. We have the failures, what happened with Luna 25. Biodiversity of Northeast, an article related to that. Then Fukushima nuclear power plant of Japan. Bharat NCAP and African Union's bars Niger over coup. And also we have some practice questions. So let's move on to first a strong case to restore the section 8.4 of RPA, Representation of People Act. Particularly we are talking about 1951 Act, which talks about the election, Election Commission of India, about the candidates and all. The 1950 Act actually talks about the voters, but the 1951 we are talking exclusively about Representation of People Act 1951. So we know this actually has been in news since the disqualification of Rahul Gandhi on being convicted and sentenced to about 2 years of imprisonment in 2019 defamation case. Now with this, like the section 8.4, we have particularly deal with a certain case called the Lily Thomas versus the Union of India case in 2013. In this particular case, the section 8.4 of the Representation of People Act was invalidated. So let us first look into section 8.4. So if you are looking at this, we have to particularly know about section 8.3 and section 8.4 of the Representation of People Act 1951. So the section 8.3 talks about a person convicted of other offence, or if a person is disqualified and he gets a criminal offence or imprisonment of 2 years or more, that person will be disqualified, and also this disqualified will continue for another 6 years, totally of 8 years. That person will be disqualified. Disqualification continues till 6 years even after the person was released from the jail. So if he did a criminal thing, he got an imprisonment of 2 or more years. So that time he is disqualified. Even after he is released from the jail, this disqualification will continue for another 6 period. So if he is in jail for 3 years, then 3 plus 6, 9 years. So critically that goes on. Now like MLAs and other like MPs are actually disqualified through these sections or the other articles of our constitution. So there is actually a certain kind of protection that is provided to them as well through section 8.4. This is the section that is in news. So through this section, it's kind of creating a loophole through which the MLAs and MPs, they can actually go for an appeal. When they are actually they can protect the sitting MPs and MLAs from being disqualified under the above provision. If they file an appeal within 3 months, about 90 days, they have time to actually appeal, and in this time period they can actually still remain in the parliament or until the day in which the decision on the appeal actually comes. So he can actually continue as a member of the house till the completion of the term or the date at which the decision on this appeal that which he has given. So this section was actually removed by the Lily Thomas case versus the Union of India in 2013, which the case stated that this was actually criminalization of politics, and thus they removed the section 8.4. Thus under the legal provision cited, there was no instant disqualification of a sitting mission. In legal qualification, like under this, there was a loop for section 8.4 under which the person, if even disqualified, he can still continue. But after removing this section, when section was removed, then there was instant disqualification of the person, like we have seen in the case of Rahul Gandhi. But after the court actually struck down this provision, the sitting legislator is disqualified the moment the court orders conviction. Now there was time period of appeal of 3 months, now this is not available, and the moment at which the court actually gave out the conviction, the person, the legislator or the MP is actually disqualified. The top court state that article 102.1 and also another article 191 clause 1. This also deals in the Constitution of India, deals about the case of disqualification. This article 102 deals about the disqualifications of MPs in the parliament, and 191 deals about the disqualification of members from the Legislative Assembly and Legislative Council of States respectively. So, the top court said that as per the article 102(1), it does not create any difference between a sitting member and as well a candidate who is in for election for a particular seat, so far as disqualification is confirmed. The Supreme Court went ahead and stated that the Parliament has no power to actually exempt a sitting member for 3 months and thus struck down section 8(4). So, that is what a glimpse of what Lily Thomas case 2013 was actually talking about. This section 8(3), as I have told you, simply states that a person who is convicted with an offence and sentenced in prison for not less than 2 years shall be disqualified. It means that the person should, like the article presently doesn't talks about, the section doesn't talk about immediate disqualification of the person. It is say shall be disqualified, which means that another committee will come, it will take some time for the disqualification of the person we are talking about. It doesn't actually means the person stand disqualified, which means immediate disqualification of that person. This is some difference that the author has mentioned in the article. The section clearly talks about shall be disqualified, which means that there is another committee coming in, they have to decide on the disqualification and such. It doesn't mention stand disqualified, which means that now as per the current system, the person who is the legislator is actually immediately disqualified based on the convention of the code. The only condition is that the person shall be disqualified from the date of conviction. So, it appears that the act of the instant disqualification of Mr. Gandhi did not have a sound legal bias. So, what is a sound legal bias? As per article 103, a sitting legislator can be disqualified by the President of India. But presently all the disqualification, the notification was all released by the Secretary of the House. These decisions are not taken by the President. So, the author is stating that the President, as per as per under article 103, the President can actually take disqualification matters into the hand. Now, disqualification and sentence quantum. So, if you are looking in the past cases by 1980s and 1990s, the several high courts have stated that if you are actually disqualified, if you are disqualified once even after completing your term, this case is put on stay. Like in the case of Rahul Gandhi, Supreme Court put his case on stay, but his disqualification has been removed. But in the 1980s, 1990, even if the conviction was put on stay, the disqualification would continue. This came to a change via the Jayalalitha case in about 2001, where the High Court stated that the moment the sentence is suspended, the conviction should be deemed to have suspended and the disqualification will cease to exist. That is what in the Jayalalitha case, the Madras High Court has stated in 2001. So, the judgment of Lily Thomas case has actually played a havoc in the lives of the legislator. Now, they had 3 months of time to actually give an appeal. Now, even if there was actually a foul play between this, they had a time to appeal and make their case. But with the immediate conviction and the immediate disqualification, these legislators are not actually getting a chance to open up themselves, to say that these accusations are false and this was a false play. Now, that right has been taken away from these legislators. The essay struck down section 8(4) on the ground that Parliament has no power to provide for a special dispensation for convicted legislators. That is what the Parliament has stated. The author states that the Parliament can bring a suitable legislation or amendment again to the article 102 to enable Parliament to restore the invalidated section 8(4). So, that is what the author states. These states that the rights of the legislators should also be protected. They also should be given a right to appeal rather than disqualification based on the conviction immediately. That is what is happening right now. So, I told you about 2-3 articles here. I told you about article 102 clause 1, which deals about the disqualification of members of the Parliament based on if the person has office of profit, if the person has unsound mind and stands as described by a competent court, then undischarged insolvency, then he is not a citizen of India and also disqualified by Parliament under any other law made by the Parliament. This 19 191 also deals about the disqualification in the case of State Legislative Assembly or Legislative Council. The article 103 talks that if any question arises whether a member either of the House of the Parliament has become a subject of any disqualification mentioned in the clause 1 of the article 102, that is 102 clause 1, that is this article. If a person becomes disqualified based on that, the question shall be referred to the decision of the President and his decision will be final, which means that as per the 102(1) clause 1, this article, if any question arises about the disqualification of a person based on 102 clause 1, then the final decision about the disqualification of that person will be taken by the President. And before President takes this decision, he should also consent the opinion of Election Commission of India. So that is the whole article dealing about. So let's move on to next topic. We have understanding the failures of Luna 25. So Luna 25, as you know, is a Russian Roscosmos mission. It was launched in August 11, but by August 20 they lost contact with Luna 25. It crash landed into the moon. So this Luna 25 was also reached to the south pole of the moon to soft land, so that they can actually study the properties of lunar soil and the atmosphere. So why did Russia launch Luna 25, and was this Luna 25 and Chandrayaan 3 on a race? Now this project Luna 25 has been going on for a lot of decades. For about it was started in about 2010. Initially the project name was actually Luna Globe, but this was actually later changed. This Luna 25 was co-developed with the help of China as well, and since last 44 years Russia was actually not able to successfully launch any interplanetary missions as such. This Luna 25 and Chandrayaan 3 were not in a race because Chandrayaan 3's development started around 2019, whereas Luna 25, as I have told you, is going since 2010s. And there was a lot of delay because of COVID-19, and Russia has been helping India in a lot. Even in Chandrayaan 2, Russia was helping in India. Even going Gaganyaan mission, Russia is actually helping us train the crews. So there is no such competition going on between Luna 25 and Chandrayaan 3. Now, what happened to Luna 25? Even they are not clear, so they are actually putting up a committee to deal with it. They have stated that it's a very technical issue that has technical problem that has arise because that Luna 25 actually kind of attempted to modify its circular orbit to the moon, and then there was actually some pre-orbit going on, and thus it applied more thrust than required, because of which it crash landed to the moon. Then Roscosmos itself lost contact with Luna 25 as it was performing this maneuver. So as it lost contact, there was no way in which the Russian agency could actually maneuver it back. So why is that Russia couldn't bring it back to the situation? In the case of Chandrayaan 3, we have a lot of help. We are getting help from NASA, we are getting help from the European Space Agency. There is like the south pole of the moon is the backside of the moon. So from Earth we don't have a clear visual of that area. So you need a particular satellite setup so that we have a three-way kind of communication system. So I told you this is the far side of the moon, about 41% is the far side of the moon, which we humans cannot see. So even if this is Chandrayaan 3, we need a satellite so that we could actually get a connection, a satellite communications happening. But in the case of Russia, what happened is that with the ongoing Russia-Ukraine war, they lost the goodwill of a lot of nations, because of which they couldn't actually get the required satellite systems for the communication. Now Russia only has 3 such satellites, 2 within Russia and 1 in the Crimea section, which Russia has actually in it. With this 3 satellites, they couldn't actually complete the process. They need more. Like the problem was that Russia can access only this communication when the moon was directly over Russia. That was the only time in which Russia could actually instigate the connection. But that is not the case with Chandrayaan 3, because we are getting a lot of help from a lot of countries where the satellites, we can actually access their satellite systems and data as well, because of which we can actually see every move and launch of the Chandrayaan 3 more specifically and clearly than Luna 25. So what is next for Russia? Russia is not be disheartened. They are going up with Luna 26 and 27 missions along with China. China and Russia are also actually going to launch an international stations which is actually near moon space station, which Russia and China are actually going to launch, but there is a lot of delay going on within it. Roscosmos has already planned for Luna missions 26 and 27 as part of the first phase of the operations. But with the failure of Luna 25, they are actually going to get some setbacks, and also there is a lot of sanctions from the Western countries which is actually affecting Russia right now. Moving on, we have another article on protecting the biodiversity of the Northeast. Majority of people actually live in the city areas, but when we think of a vacation, we actually think on a place where there is a lot of greenery, where there is backwaters, rivers and lakes. So we actually book such kind of area. If we are from Kerala, I'll be booking backwaters in Palakkad or such, because I want to see the beauty, I want to see the scenery. So the problem is that which a lot of tourists attracted to this green and this waters, bodies and such kind of, there is actually a lot of tourism based development in resort near to the water bodies and such. This tourism actually generates a lot of revenue for the central government, the state governments, and it actually boosts the employment for the locals. But all this is in the cost of environment. These such construction takes place near to the water bodies or near to the forest as such, which is actually hampering the environment at the least. So there is a case in Meghalaya, cleaning of Umiam Lake versus the state of Meghalaya. This is a recent case in 2023. In the absence of any other employment opportunities and in the name of promoting tourism, the natural beauty of the state should not be destroyed. So that is what the High Court of Meghalaya stated in this case. Even if they are promoting the name of promoting tourism, if you are also generating a lot of infrastructure and employment and such, that is good, but it should not be in the cost of the environment. So the Meghalaya High Court was hearing, like, it's a public interest litigation given on the cleaning of the Umiam Lake. You should know the Umiam Lake, where this Umiam Lake is, what are all near it, because you can get a prelim questions asking directly this Umiam Lake, where is this Umiam Lake located in. You could get such question also. The court in this observation of the Meghalaya water bodies, in the state of the Meghalaya water bodies, there is a guideline. They said that they did not deal with the most serious aspect of increasing infrastructures along the water bodies. Even if cleaning of the river is good, the main thing they didn't address is that there was an increase in infrastructure conservation at the cost of the environmental degradation. They didn't address this. If you are looking at the Northeast, if you have ever been to Northeast, you know that it's very beautiful. There's a lot of greenery, forest, everything. It's a biodiversity hotspot. Like, even if it's a biodiversity hotspot, we could get a lot of minerals, resources, oil, natural gas and such are available in the Northeast area. If you are looking especially areas like the Garo, Khasi, Jaintia hills in Meghalaya and the Brahmaputra valley, these are resource rich and they are also biodiversity hotspot. Even if they have all these green belt, if they are green belt region, they are not very developed. They lack they are industrially backward, they have deforestation, a lot of floods coming up. The existing industries are actually causing serious problem to the environment of the region. So, environmental loss. Even if there is environmental concern, there is environmental blooming as well as degradation. There are environmental laws as per the Indian Penal Code 1860. We have section 268 to 290 dealing with the offences related to the polluting of the environment, polluting or actually damage of the environment. But the 6th schedule, you should know that in the Northeast there is, in the case of Northeast area, tribal area such, there is 6th schedule which actually talks about particularly 4 states, that is Assam, Meghalaya, Tripura and Mizoram. So in these 4 states there is, the 6th schedule is actually in operation, which states that the state government doesn't have an authority, but they have created an autonomous district council which actually takes the decisions on this area. But this autonomous district council doesn't actually look into the development of the Umiam Lake in particular, because of which the state government has no say to what have to do, because the 6th schedule actually protects all these district council and the state government doesn't have any say on it, and this particular district council has not done anything regarding to the Umiam Lake. And also with a lot of this PIL, public interest litigation and judicial activism, there has been a lot of concerns and there is a lot of rescue measures for the environment as well. So if you are looking especially in the Northeast area, the National Green Tribunal, that which came under the National Tribunal Act of 2010, they actually to curb the illegal mining. There was illegal mining happening in Meghalaya, so the NGT actually imposed a fine of 100 crores in Meghalaya. Similarly in Manipur, they fined about 200 crore in 2022 because they were not managing the waste properly. So because of all this resignation, PIR, this judicial, quasi-judicial body which are actually taking measures and giving punishment to states so that they can actually rescue the environment. So the pressing priority. Even if you are looking into northeast, we need the development. These are underdeveloped areas, so we need development, we need more employment, we need growth. But these should not be at the cost of environment. So if you are looking in the Northeast Industrial Development Scheme, if 2017, they have a particular list called the negative list. If a particular entity or an organization doesn't comply with the rules, they doesn't actually have consent from the pollution board. If they are not taking their environment standards properly, these kind of entities or organization will be put under the negative list of Northeast Industrial Development Scheme. We have also Act Fast for Northeast. The Act Fast for Northeast mainly includes trade and commerce. It does not include environmental protection. So the author also suggested under this Act Fast for Northeast policy, this kind of environment and ecology preservation should be actually added. If we are actually aiming for a $10 trillion economy, but we are actually neglecting the environment, now this is a waste of goal. Now India is a goal which is not actually worth pursuing. If we actually have a dream of becoming a $5 trillion or $10 trillion economy, we need to also pave a way for the development of environment also. So that is what the entire article talking about, particularly in the case of Northeast, where there is actually, we need more preservation because Northeast is a very fragile area. So even if you are pushing for development, we should not actually push more, because there is environment, it's a very unstable area. If you are pushing for a lot of development, it's going to got a lot of landslides, avalanche, floods as such. So this should come, the balance of the development in the Northeast area should be more balanced. Now let us talk about the Fukushima nuclear power plant. So you see here, in Japan, like we know that Fukushima from power plants, Japan is actually aiming to flush about 1.25 million tons of wastewater from this embedded Fukushima nuclear power plants. So if you are looking in 2011, there was a major earthquake and tsunami affecting this Fukushima nuclear power plant. So they have to use a lot of water to maintain, used as coolant for the reactors. So this project will actually take about 30 years. So there is a lot of international criticisms and concerns over this particular project of Japan. So you see, March 2011 there was earthquake as well as followed by a tsunami which actually affected the Fukushima nuclear power plant, particularly in Daiichi. There is two Fukushima, Daiichi and Daini. Particularly Daiichi, 4 places were hit. There is showing 4 places: Daiichi, Daini, Tokai and Onagawa. These are like 4 places where the earthquake hit and the nuclear power plants was damaged. We are particularly talking about Daiichi power plants. So this was the diesel generators was damaged. Because the diesel generators was damaged, there was no power to actually keep on the coolant supply. So when this all disrupted, it disabled the backup system and all the radioactives started leaking out, and it caused a lot of explosion, and this led to the spread of radioactivity by air, by water, in soil, and it affected the local population. Now the Japan, what they want to do is to flush out this water from the power plant and use that water which was used to actually cool the reactors, flush this out, plus rainwater which also contains rainwater and other groundwater, flush it out the Pacific Ocean. But the water in question here has a lot of radioactive isotopes which can actually damage the health of marine animals, humans, and the entire, like it could actually affect a lot of people. Even the marine biodiversity will be affected if this water is actually released. So if you are looking, we do not have a particular threshold to say which this radioactive level, above this is very harmful or below this is very active. Radioactivity at any level is harmful. Like we can say that it could actually increase the risk of cancer and other diseases and health problems as such. When such poisonous water is actually released in the water body, it could affect the local community and even the marine biodiversity. Now the problem and the question here is that they are not treating this water correctly, which means that they haven't removed the element tritium. This tritium is easily absorbed by the marine animals and such bodies of the living creatures. The other isotopes of ruthenium and plutonium, which is also which could also persist longer in this water body is still remnant in that. Why they are not flushing instead of treating? Because they don't have so much of storage system, because of which they have to flush it out. So that is what is happening, and so this is creating a lot of concerns and criticism all over the world. We have Bharat NCAP. Now Bharat NCAP is a new car assessment program. This assessment program through which a company can come voluntarily, and the government, this committee will actually assess this cars for their safety, indicating when a crash happens how much of safety the persons will get. Now this new Bharat New Car Assessment Program is in parallel to the Global New Car Assessment Program, which is a project by a UK based company known as Towards Zero Foundation, by which they actually follow or universally they adopt the promotion of United Nations Motor Vehicle Safety Standards worldwide. So that is the Bharat New Car Assessment Program. So under this, it will be applicable to car which has seat less than 8 passenger cars, including the driver's seat, which has seat less than 8. There will be rating within 1 to 5, where they will assign the vehicle, they will crash the vehicle and see if the person comes out alive or how much safety it actually gives to the person. Like this 1 to 5 is based on three categories: occupant protection, child occupant protection, and safety assisted technologies which is present in the car. So these three will be, the rating of 1 to 5 will be between these three conditions. So the Bharat NCAP representative will visit a company or an organization or a dealer. They will actually go through the car and select 1 or 2 from random, and then they will test it. Then they will actually give out this information or the results in their website, which is partnered along with the Central Institute of Road Transport. So this program is purely voluntary, but the governments can also make some recommendation for this committee to look into certain companies as well. If the company is selling a lot of units, or the ministry thinks that there is a safety concerns regarding this car, then they could actually take up this program and go they can actually check the vehicle situations. Now we have African Union bars the Niger over coup. So we know that there is coup happening in Niger. So in this article we need to talk about two bodies, that is the African Union and the ECOWAS. So both stated that they will suspend the Niger until the president Mohamed Bazoum is actually restored. So the ECOWAS stated that it is actually ready to intervene as a last resort, but continues to press for a more diplomatic solution. So African Union is actually a continental body. It consists of about 55 members. This was started in the year of 1963. It was initially named the Organization for African Unity, and it was founded by the independent states of Africa. It consists of about 55 members. So it was initially called the Organization of African Unity. So their main aim was to promote cooperation between the 55 African states. Then in 1980s, a Lagos plan of action was actually adopted by this organization. This plan suggested that the Africa should should minimize their reliance upon the Western states, and then increase the promotion of intra-African trade. And also in 2002, this name was actually changed to African Union. This African Union name came in 2002. Now this is not something which you need to know, but which you should actually know a bit. Now we have ECOWAS, which is the Economic Community of West African States. Now this is actually a regional intergovernmental organization. This was created between 15 member bodies. Now you see here, this western area of Africa is the 15 countries which is dealing with ECOWAS, where you can see Nigeria is also a part. Now this was also created by the Lagos Treaty. The ECOWAS forms foster economic integration, cooperation and development of this West African nation. Now this ECOWAS is purely for West African countries, whereas the African Union consists of all 55 members of Africa. Now the secretariat is at Nigeria. Now their goals is economic integration, free movement of trade, people and other goods and services, regional cooperation. We have then borderless region governed by democratic principles, and also address the security issue, coups and all which is happening in the area, because you can see particularly this area there is a lot of coups in this area. We can see coups in Mali, Burkina Faso and now in Niger. So all to promote the peace and stability and cooperation trade in this region, ECOWAS was created. Now we have some practice question. In the recent years, Chad, Guinea, Mali and Sudan caught international attention. For which one are the following reasons? Now this was a recent question which was asked in 2023. The answer is successful coups. All this region, Chad, Guinea, Mali and Sudan, these are very areas where a lot of coups have happened in Africa recently. Now we have a next question. The functions of heavy water in a nuclear reactor: slow down the speed of neutrons, increase the speed of neutrons, cool down the reactor, stop the nuclear reaction. So the function of heavy water is slow down the speed of neutrons. Then I have to practice mains questions. We have like, can a convicted legislator based upon the Representation of People Act 1951, and I have one about the energy growing needs of program in India, which this is a previous year question which is asked in 2018. So please work this out and we will be discussing it tomorrow. You can get the PDF from our Telegram channel Gallant IAS. Thank you. Have a nice day. I will be seeing you again tomorrow.